turn on the live stream. Awesome. Okay, we'll start again. Good morning, everyone. Welcome to the Committee on Veterans and Legal Affairs. We've got a quorum present, and we are assembled virtually today to work on a number of bills that this committee has heard over the past couple of weeks. Before we get started with our workload for the day, we'll begin with committee introductions, starting with the House Chairman, Representative Chiazzo.
Thank you, Mr. Chair. Good morning, everybody. Happy Thursday. Chris Chiazzo, House District 28, beautiful, sunny, and very warm West Scarborough.
Senator Farron.
Good morning, Mr. Chair. My name is Brad Farron. I reside in the beautiful town of Norridgewock on the banks of the Kennebec River and represent the fine citizens of Somerset County and the town of Rome and Kennebec County. Thanks for being here this morning, folks.
Great. Representative Kinney.
Thank you, Mr. Chair. I'm Mary Ann Kinney. I represent the House District 99, which includes the towns of Brooks, Vernon, Freedom, Jackson, Knox, my hometown, Monroe, Thorndike, Troy, and Unity.
Representative Riley.
I'm Representative Riley. I represent House District 34, which is part of my hometown of Westbrook.
Representative Wood.
Good morning. I'm Barb Wood, and I represent House District 38, which is the western end of the peninsula in Portland.
Representative Tuttle.
John Tuttle, District 18, primarily the east side of Sanford.
Representative Corey.
Good morning. I'm Patrick Corey. I represent House District 25, which is part of Wyndham.
Okay, great. And my name's Louis Lucchini. I represent most of Hancock County in the State Senate. With us today, we have our committee analyst, Sam Prower, as well as our committee clerk, Karen Montel. And so we'll begin with, I think we have one bill that Sam's worked on. So we'll start with that, and then we'll move to having Janet and the other bills in. So with that, we can start the work session, open the work session on LD 619. And that is an act to allow Christine Pratt to be buried at the Southern Maine Veterans Cemetery. So Sam, I think we've already worked this one, right, before?
Yeah, that's correct. And I can give the committee a refresher if you would like. And I also can pull my bill analysis back up if you'd like. But I don't know, maybe if you have other things you want to get to first. Or...
Yeah, I think the title's pretty self-explanatory. And Representative Chiazzo.
Thank you, Mr. Chair. I think it's a pretty straightforward bill, but we have the sponsor on the committee, so hopefully we can just get a quick update from him to see what the status is.
Representative Tuttle. Yep.
Thank you, Mr. Chairman. As we've said, the federal government works very slowly, and so I'm still waiting to hear from them. I've talked to the congressional offices, and they advised me that it will get there, but it's going to take more time. So if as most of you know how strongly I feel about this issue, I would like to keep it over to next session so that we can do the proper thing for this bill. I'm hoping the committee would allow me to do that.
Okay, it's Senator Farron.
Thank you, Mr. Chair, and Representative Tuttle. I know how passionate you are about this one, and I respect that. And I will support a carryover, but I also think that I just want to kind of lay out there, my personal feelings on this is that looking for this exemption has the potential, and I know you're going through the federal piece or whatever, to set a standard. And I know that the department has come forward and said that there are ways that we can honor the work that Christine Pratt has done. And I find myself in a very difficult position to support this bill. But your good work on the committee and what we've done for the veteran stuff, I would support a carryover on this if that's what you request.
Thank you, Brad.
Thank you. Representative Chiazzo.
Thank you, Mr. Chair. I mean, I would concur with Senator Farren to some extent. My primary concern is to make sure we don't put any federal funding at risk. So I want to make sure that we get assurances from the federal side before we act. So with that in mind, I would make a motion that we carry over LD 619 to the next session, please.
Okay, we have a motion to carry over. Is there a second?
Second.
Second.
Okay, seconded by Representative Riley. Any further discussion on the carryover motion of LD 619? Okay, seeing none, the motion before us is to carry this bill over. Karen, can you please call the roll?
Senator Lucchini.
Yes.
Senator Lucchini, yes. Senator Hickman. Senator Hickman, absent. Senator Farren.
Yes.
Senator Farren, yes. Representative Chiazzo.
Yes.
Representative Chiazzo, yes. Representative McCray. Representative McCray, absent. Representative Tuttle.
Yes.
Representative Tuttle, yes. Representative Riley.
Yes.
Representative Riley, yes. Representative Supika. Representative Supika, absent. Representative Wood.
Yes.
Representative Wood, yes. Representative Kinney.
Yes.
Representative Kinney, yes. Representative Harrington. Representative Harrington, absent. Representative Corey.
Yes.
Representative Corey, yes. Representative Dollar. Representative Dollar, absent. 8 in favor of the motion, 0 opposed to the motion, and 5 members absent, Mr. Chair.
Great, thank you, Karen. Representative Kinney.
Thank you, Mr. Chair. I'm just curious so that I can help out my members who are absent. On carryovers, do they vote or is it like tabling?
I mean, typically we do carryovers like tabling as a present, and I know other committees are doing it differently this year because of Zoom. But I think typically that's the way we do it. Yeah. Representative Tuttle.
Mr. Chairman, I want to thank the committee, and it really does mean a lot to me, and I appreciate very much your help on this issue. I'd like to thank all the committee members individually. Thank you.
Yeah, thank you. All right, thank you, Sam, for your help, and I think that's all for your bills today, right? All right,
Correct.
thank you. We'll see you later in the week, I'm sure.
Yes.
So welcome, Janet. I think if it's best, maybe we'll start with the language reviews. I mean, we'll probably have a bunch of these over the next few days that we're just trying to keep paper moving as all the production offices are slammed with the amount of work that's hitting them now. So we'll try to move stuff quickly as much as we can. So.
Okay. I just had to move which thing was on which screen because you can only share it from one of your screens. Crazy technology.
I know. Screen sharing, I haven't quite figured out yet.
So with your indulgence, I'm going to start with the preliminary language review, which is on LD 1155. And that is an act to require election transparency and audits. There is, for some reason, it doesn't want to show the whole thing. Let's see if I can get to, there we go. So the vote was 9 ought to pass as amended, and that's this amendment, 2 ought not to pass, and then 2 for a minority amendment, and I'll show the minority amendment in a second. But I did just want to come back because I was not clear exactly on what everybody wanted as far as effective dates and everything surrounding the audits. And then we've since received some further communications from some of the stakeholders that make me even further question what I wrote down as what everybody voted. So I did want to check that this is what everybody wanted. So the first part of the amendment just amends the portion of the bill that talks about an election guide and the complaints and all of those things. So this is basically just adopting the proposal that was presented at the work session. So I'm fairly certain that I have what you wanted here, which was that the guide to elections would be by February 1st of every general election year, but referred to as an even number year. Slight change to the language about the polling place requirements, likely because they aren't really rules. Changing the election complaints procedure to be a log of public concerns, so that the Secretary of State would collect and log those concerns from the public about the conduct of elections, indicating any action that might have been taken, and then instruct voters about the process for logging these concerns in that election guide I just talked about. That would be by February 1st of every election year. Then there is an election report section. And I did change this slightly from the way it was presented because of the concern I have about when the election audits are going to take place and the repealing date in there. So I'm going to come back to that in a second, but I did just want to show you that this is the election report that would be by December 15th of the year following a general election, but there was a request to make it begin in 2023, so it wouldn't apply this December, so should the legislation be enacted. And at the work session, you talked about making sure that it only requires the logging of complaints, not the logging of concerns, and not actual complaints, to reflect the other part of the amendment. Removal of the requirement to report on the central voter registration system, because that's already report, and instead to say it would be a summary. I put above here, although it was down here in the proposal before you, that there would just be a summary of any previous reports submitted to the committee, just to remind everybody of what they are. And then there would be a summary of post-election audits. That's going to become important in a second. A summary of recounts conducted, and any recommendations for remedying problems in the election process. So you saw most of that there, although I might have reorganized it slightly. Then there was a provision that was presented to you about proposing for post-election audits. I rewrote it a little to try and make it clearer, at least the way my mind works, which is possibly not the way anyone else's mind works, in which case you can instruct me to change it back to the way it was. But it would define eligible elections to be contested elections for state or federal office, as well as any referendum elections that are statewide. The requirement would be that the Secretary of State would begin these post-election audits in 2024. The audits would be conducted, they would be risk limiting audits, basically. I forgot I can't highlight in this particular program, but they would be conducted on the basis of the statistical principles designed to limit the risk that there's an incorrect outcome. That's the risk limiting part. The risk limit is still going to be established by the Secretary of State prior to the elections. And then auditors are still directed to visually examine the original paper ballots that are selected for the audit and review records documenting the chain of custody. And any additional documents, it said selected by the Secretary of State, but I didn't know if that should be through rulemaking, because this was a rulemaking provision generally. So I just highlighted that for your consideration. The selection of the elections to be audited. Those would be selected according to criteria established by the Secretary of State by rule. There was language in the amendment before you that these are public proceedings, so that the public should have notice and the opportunity to attend, although space may be limited. So I put that in here in a separate subsection, but I just cited to FOA to clarify, but I still included the whole part about there might be insufficient space. And I modeled this language on the language we have for polling places and the insufficient space that might exist there. And then the rulemaking is there. Then there was an idea that this would be required beginning in January 2024, but there was a request to have this section repealed after the 2026 elections. And that's where I really became confused, because The idea was to have a repeal date and to allow the legislature, if it wanted to report out a bill to get rid of this repeal date if the audits are going well. So I was trying to figure out the audits would take place after the 2026 election. That would take time through the end of the year. And then it would be in 2027 that you'd need to repeal it. So I picked a date which would be in the middle of that legislative session so that there would be time to pass legislation repealing the repealer. As far as some kind of activity that would trigger the right of the committee to report out a bill, you could obviously seek a joint order, but if you wanted the right to report out of a bill, that right can be triggered by the election report. The problem is that's not going to be submitted until December of the odd number year, so that's struck me as being problematic. I had written down that the pilot project, which was part of the original bill, would be kept, and that pilot project would still follow the November 22 elections. And there would be a report after that pilot project. But I had written down in my notes that after that November 2022 pilot project, all of the post-election audits would be required starting in 2024. So this is how I would draft that amendment. So that only leaves me with the question of what's the triggering event that gives the committee authority to report out legislation to repeal this repealer if you wanted to do so. I know that that's kind of confusing, but that's where I was stuck in the question I had, which is why I wanted to come back to you today and make sure I really understood this. Because if I read through the information that was submitted by the stakeholders, it's not clear to me that they viewed your vote the same way that I did. Hopefully that's making sense.
Okay. Representative Tuttle, do you have a question?
I do, Mr. Chair. Could we check with the Secretary of State and maybe get their clarification on the repeal of April 15th, 2027 to make it clearer for all of us? That would be helpful, at least for me, Mr. Chair.
Yep, we can bring in Secretary Bellows. And Janet, just so I understand, so after the pilot, it still says that they must do audits, or does it just give them the authority to do it?
What I had written down was that you wanted the authority to conduct the pilots. After that, to require post-election audits in 2024 and 2026, and sunset after 2026, but allow the committee to repeal that sunset date if they wanted. So I didn't know if the best approach was to say after the 2026 require another report, but the report that is going to be given every December of the odd number year is supposed to include the results of post-election audits. So it seemed odd to me to create another report doing the same thing, although I'm perfectly happy to do that, but that's sort of the conundrum I was in.
Okay. So we have Secretary Bellows in. Did you hear Representative Tuttle's question, Secretary Bellows?
I did. And I also want to recognize Deputy Secretary Flynn. We had not requested a repeal date, but I understand that that was part of the compromise that the committee reached. We certainly would be comfortable if the legislature, if this committee wanted to require a report after the 2026 post-election audit prior to April 15th. I think that might be something that we could produce, or you could eliminate the repeal and have that report trigger a review of a potential repeal. But we definitely defer to you. And I want to invite Deputy Secretary Flynn to weigh in as well, because she is so experienced in meeting legislative deadlines and reports, and see if she has strong feelings. Again, just want to, we don't need a repeal, and think that once we set this up, we're excited to move forward with it.
Okay, Representative Chiazzo, did you have a question? I don't think we have Deputy Flynn quite yet.
Yeah, no, not a question. I think if I'm recalling, and my notes could be off a little bit too, I think that if I recall, the concern was that this was presented as a pilot project initially, and the pilot was, it was pilot and then immediately into statute after that. And I think the concern, if I recall, and again, I could be off and I'll weigh in for the rest of the committee as well. I think our concern was that it would immediately go into statute regardless of what the outcome was. And we wanted to have some kind of check back mechanism before it went permanent into statute. So I don't know if that, and I'll defer to other committee members if they have different recollections, but I think that was my recollection, is we just wanted to have some check back mechanism first to make sure the program was functioning the way we wanted it to before we made it permanent statute. So I don't know, I mean, I don't think that clarifies the dates and when to do that, but I think if I recall, that was the intent. But happy to hear other things if there's different opinions on the committee for sure.
Yeah, and we can certainly take more time with this one without keeping it moving, just to make sure everybody's clear on it. If more time is helpful now that we've seen the language, then we can, I guess, just not report it out for a bit and just, I mean, obviously we don't have much time, but now that we've seen the draft, we can kind of move it around with people and see what needs to be fixed or not, or what makes people.
I don't know if this is helpful information to add. Maybe not, but just to remind everybody, the election report that's required in December of the odd number years, anytime the legislature gets a report that's required by statute, you have authority to report out legislation in response to that report. It does not need to be stated in the law, so that is automatically true. So in the December of the odd number year, when you get that report, you have that opportunity. I would point out that it's the original draft said that that report would go to the legislature. I suggested changing that to have it go to this committee to make it a little more obvious to you all when you get it, that this is your opportunity to report out legislation. Sometimes when it goes to the whole legislature, that sort of gets lost. Under the joint rules, you're allowed to report out legislation in the session during which the report is received, which is a little odd because nobody's usually around in December. But I think that would carry over to the next session you actually show up. So that would be in the January of the even number year. So the second regular session, most likely. So that's the way it works, which is why I'm fine adding another report on top of that. I just wanted to point out you are getting a report. It's just at the wrong time. You always have the authority, however, to report out legislation if you get a joint order. And part of the job that our researchers in this office have is to track every repealer that's in statute. And they remind us before every session begins that there is a repealer and it's within the jurisdiction of the VLA committee. Tell the chairs, remind them so that they know to talk about it with the committee if they so choose, so that the committee can decide whether it wants to ask for a joint order to report out legislation on it or use a vehicle that you already have. So it's, if you're worried about it being forgotten, it shouldn't be forgotten if we do our job.
And we also have like the rules report that lets us do some legislation, right?
Right, and you do get the central voter registration report around the same time. So there are possible vehicles. It's just not clear to me if you want an actual report on that because it's that important to you that you want to make sure dot all the I's, cross all the T's, which is totally fine, but that's what I wanted to ask.
Okay, Representative Chiazzo.
Thank you, Mr. Chair. Yeah, I certainly don't want to be creating more work for people. I think as long as the intent is there to make sure that we have the ability to kind of check back and make sure the process is working the way we want, I'm perfectly content removing I would be personally content removing the repeal date or whatever that was, as long as this committee has the ability in the future to go back and evaluate and make sure that it's performing the way that we want. And I don't necessarily think we would need a special report to do that. We would just, if I understand you correctly, Janet, as the odd year report comes out, it would be flagged by OPLA to say, hey, just so you know, this is coming and this is where you want to consider a repeal. This is the time to do that kind of thing, right? Is that correct?
Yes, we track those and we warn you.
So I'm perfectly content streamlining it and making it efficient and simple if that's the normal process. But again, I will also defer to other committee members if they have other concerns.
Sure. So obviously if we change the bill, we'll need to reconsider it or do anything like that. So if anybody has any questions for either Secretary Bellows or Deputy Flynn, you can ask them now, or we can just hold it, take a look at this, and then if there needs to be changes, we can reconsider on Thursday or Friday, just whichever works for people. Okay. So I guess seeing no other questions, Janet, we'll just hold this one a bit before we send it out, and then if people are good with that, and then by Friday we'll send it out regardless. So.
Okay, so now that I've shown it to you, I can send it to the Secretary of State's office if they want to have any further time, because they just saw it for a half a second on a screen share.
That's what I'm thinking. Now that it's public, people can weigh in a little more on, once that they can see it. So.
Okay. I'm just going to write a note to myself to do that.
Okay. Thank you.
And then I do have questions on the minority amendment too.
Oh, yeah. Yep.
So this is the minority amendment. It's a two-person amendment. I think we have one of the members here, so that's good. Okay. So this amendment is very similar to the majority amendment as far as the whole election transparency provision and changing the due dates of the guide and the logging of concerns rather than the compiling of complaints. But what it does do is it changes who conducts post-election audits to a new board that is modeled on the Board of Canvassers, which is how it was described at the work session. But it just has a new title. So it's the Post-Election Audit Board, and they receive a legislative per diem. And if we go down to that provision, just to make sure this is the way that group wants this to be written, the Post-Election Audit Board would have 5 members appointed by the governor, 2 of them from each of the political parties holding the largest number of seats in the legislature. And those would be selected by the governor from a list of 3 qualified nominees who are enrolled in the party. And that would happen by January 1st of 2022, and then as needed after that, whenever there are vacancies. One member of the board would be enrolled in a political party that isn't a major political party, or if there isn't such a minor party that's qualified, they could be unenrolled. And what I wasn't sure about, even though I was given that instruction from the minority report, was the Board of Canvassers requires each party to give a list to the governor. I didn't know how the governor would select this unenrolled or minor political party members. So I just threw this in here as a stopgap measure to ask you if it works, which is to require the governor to consult with all the minor political parties before appointing that 5th person. But I don't know if that works. That was just an idea as a placeholder because I wasn't sure what the minority report wanted there. Each member of the board would serve a term of 4 years, but for the purpose of staggering terms, I put down that the first 2 members from each political party would serve 2-year terms. If you remember in the Board of Canvassers bill, they served 5-year terms, which was a little bit odd and problematic for that bill, but we haven't figured out how to resolve that or if that bill's moving forward. So that's why I highlighted this as well, to see if that's the way that the post-election audit board members' terms should be staggered. And then the canvassers bill says that no one can serve more than 2 consecutive terms. And I wanted to make sure that was true for this post-election audit board as well. And then again, for the canvassers board, if you're a candidate who's been elected to any state or municipal governing body, you're not eligible to serve on the canvassing board. I wasn't sure if that was supposed to also apply to this post-election audit board. When we get to the actual conduct of the post-election audits, it's necessary to change the way that it's written from the majority report because it's no longer being conducted by the Secretary of State. So it still has the same definition of eligible election. It still is requiring the audits starting in January 2024. Instead of the Secretary of State establishing the risk limit, it would be the post-election audit board. And instead of the Secretary of State determining by rule what extra documents other than the ballots and chain of custody documents would be examined, it would be the post-election audit board deciding that. These are just guesses I had for how to change the majority report to have this board conduct the audits instead. And that's why I'm checking with you that that's how you want it. The selection of the elections to be audited under the majority report, that's based on criteria established by the Secretary of State by rule. I was not sure that's how the minority report wanted it to be. So I just generally said that the audit board selects the races themselves without any criteria. I wasn't sure if that's what you wanted. All the public proceeding things are the same. And I still think there probably is rulemaking required, but I'm checking with you to see if that's true. And I would think that that would be Secretary of State rulemaking just about how the risk limiting audit is conducted. But again, that's why I'm checking with you. Again, we have the same repeal date issue. And there was no suggestion that the pilot project be changed. So there would still be a pilot project conducted by the Secretary of State, because my notes don't reflect that that was requested to have a post-election audit board conduct the pilot project. But it left enough questions in my mind that I wanted to bring it to you before I sent it to the revisor's office to be turned into the official language and take all of their time up proofreading it and checking all the cross-references, etc., to make sure this is actually what the minority wanted this report to be.
Thank you, Jana. And if I saw correctly, I think it's just Representative Kinney and Representative Dolph on this particular report. Is that correct?
Correct.
So Representative Kinney, I can't see, all I can see is sharing screen, so I think you're in there.
I am. I'm here.
You're okay. Thank you. Did you want to respond to Janet's questions?
Yes. So I'm not sure if on the majority report, if candidates or anyone, because this was going to be through the Secretary of State's office, can they work for the Secretary of State's office after being an elected official? I mean, the Secretary of State is a former elected official. So my thought, I think, on that was not to limit out the board, I guess, maybe as far as the candidates or elected
So
members.
don't require
Right.
that type of qualification, just 2 members of the board from each of the major political parties and 1 from a minor political party or unenrolled, and don't worry about whether they were a candidate or not.
Right.
Okay.
And then the pilot project part of it, I would still prefer that to be part of the post-election board, not the Secretary of State's office, I guess was my thought.
Okay.
On that the whole idea.
And would the Secretary of State still be conducting the rulemaking for how?
That makes sense to me.
Okay.
And my thought with this was more just where financially where our state is just in such dire straits. The idea of adding 5 new positions for this was just too much for me. That's where this kind of came from. I liked the idea of the board, the idea of the audit being conducted, but wanted to try to find a different funding source for it. And I think a per diem would be less expensive to the state and the taxpayers.
I can make those changes. Thank you for letting me know. This, if I can beg your indulgence.
I know it was, I think by email it was hard to, I should have called and I didn't get around to it. I apologize.
That's okay. I just need a second of your time for me to write that down, if that's okay, with the committee. I feel like everybody's staring at me.
Just your square, Janet.
Hey, do you still want more language review now that we're in the group?
No, let's keep rolling through the language review while we're here on the topic.
So the rest aren't listed as preliminary, but that doesn't mean you can't tell me to change it, so don't feel pressured. So this is the first of several voter ID bills. and the amendments are mostly the same, but because we can't have the same title for any bill, each one has a slightly different title. So that's what's going to be the major difference that you're going to see now, because the revisor's office, I think rightly so, doesn't allow you to have the exact same title. So this is, the first one is 253, and it's a 8 ought not to pass and minority 5 ought to pass as amended report. So the new title on this version will be an act to strengthen Maine's election laws by requiring verification of identity for the purpose of voting. So under this amendment, which was presented at the work session, a voter who wishes to vote has to verify their identity by presenting one of 3 types of ID that are already listed as IDs that can be used for identity purposes in voter registration. And I have that statute attached here to remind you what those 3 types of ID are. If they're unable to present that form of ID, they would sign an affidavit giving their identity. In addition, there's language here requiring anyone who whose name doesn't match the incoming voting list because they changed their name by marriage or other process of law, they would need to go fix that with the registrar before proceeding to vote. And that's just the summary telling the same thing. There is an attached fiscal note for this. It's a minor cost increase to develop the voter identity affidavit, but it can be absorbed within existing budgeted resources in the Secretary of State's department. And then just to remind you what those 3 forms of ID are, they're a government issued photo ID, or another government issued identification document that doesn't have an ID, for example, a birth certificate or social security card. And then the third option are other official documents that give the name and address of the voter. And some examples are listed here, but this is just what is being cross-referenced in the minority amendment as the types of IDs that are acceptable. And then if you don't have those, you sign the identity affidavit. So I think that's pretty straightforward what you wanted, but it had been so long since we saw this before because it took some time to get all the pieces together. I just wanted to make sure to point everything out to you.
Thank you, Janet. Representative Corey, did you have a question?
No, I just want to say that I think that Janet did a good job encapsulating my report. And hey, if anybody wants to jump onto my report, I'm ready for you too. This is a good one.
Seeing no takers, any questions or concerns from those on the minority regarding the language review?
The next one is LD 557. I believe it's the same individuals on this minority report. I may have forgotten to write Senator Farron's initials on the last one. I apologize, Senator, but you were part of that one as well. And the only difference here is the title. So this is an act to strengthen Maine's election laws by requiring identity verification for the purpose of voting. But all of the text is the same. So it's still the same 3 types of ID. If you don't have it, you sign an identity affidavit. You correct your name change before voting if that is what happened. We're going to have the same fiscal note, minor costs to be absorbed to develop the affidavit.
Speaking here, but I guess I got a little confused exactly.
Sorry. And I again gave an attachment to give you the statute, and I put this all together in case anybody ever requests it. I can send it to you right away, and you'll have everything.
It's pretty simple.
So that's why it's all scanned again. Was everyone okay with this?
Representative Corey.
Yep, that's my report. Thank you. Another beautiful report, Janet. Thank you.
Okay, the next one is going to be slightly different, but still slightly not. So the next one is 1083. So first we have the 4-member minority report. And the 4-member minority report is straight ought to pass with fiscal note only, and there is a fiscal note. So I just want to remind you what the bill does. So let's go back down. I put the original bill text here. So 1083, which is entitled An Act to Create a Voter Identification System, requires someone to provide a photo ID document, which could be a driver's license or a non-driver identification card, as well as other options, including a passport, military ID, concealed handgun permit, if it has a photo ID, or a special voter ID card created by the Secretary of State that would be provided for free to eligible voters. So that was with the original bill. So the straight ought to pass report of these 4 members of the committee has to include an appropriations and allocations section to provide funding for free state ID cards for voters, as well as a voter education and outreach program and related expenses to implement voter ID. And so that's what this amendment does. And then there is a required fiscal note, which then just explains the need for that money. So I'll blow that up so you can read it real fast.
Great. Thank you, Janet.
Is everyone on this report, which is Representative Kinney, Harrington, Doloff, and Senator Farron, okay with this one? Okay. There is also a one-person minority report, which is like the minority report because it's Representative Corey's report that he had on the other bills, but we just have a new version of the title, which is an act to strengthen Maine's election laws by requiring verification of identity to vote. So I suppose I'm asking you, Representative Corey, if you're okay with this title.
Yep.
Beautifully written, Janet. Thank you.
The titles I cannot take credit for. Those were the revisor's office. So I don't want to take credit where it's not due.
I'll send them a thank you note.
Okay, good. They often get harassed, which in my opinion is sometimes wrong. So I'm glad you'll be sending them a thank you note. They appreciate that. They work nonstop. Oops, I just got rid of one that I meant to not get rid of. Sorry about that.
Okay. Do you want to get that later or?
No, I didn't get rid of it. I'm just a little nervous today. Okay, so the next one, I didn't realize I scanned this one together. Sometimes I scan the majority and minority separately. This time I scanned it together. So this is 1126, which is an act to update the voter registration process. You might refer to it probably as online voter registration. So the majority report of 8 members of the committee is this version. So there's a slight difference between the minority report and this first line because it strikes out this first line. All of that is striking out the title Part A because there's no longer to be a Part A and a Part B in this majority report. They're just going to be one section. So if that looks weird to you, that's what that means. Then there's a bunch of technical fixes that you're going to see throughout this amendment because the definition of the online voter registration application includes that it has to be on a publicly accessible website. So we didn't need this redundant language throughout the bill. I can't imagine what crazy person drafted it today. She must be somebody that you might be talking to right now. Then the other part of the amendment is there is this provision in existing law that talks about changing your party enrollment and it having to be on a written request. And the amendment is to get rid of that requirement because now that sort of activity can also occur through the online portal. So it just gets rid of the word written in that portion of the amendment. Then there's some more of these technical fixes. This portion of the amendment is the part of the bill that talks about the rulemaking that's attendant to the online voter registration process. And there had been a request from the Secretary of State that the committee or the majority of the committee agreed with to take this particular requirement that the application be designed to prevent an applicant from registering to vote unless they disclose their driver's license or non-driver ID number or the last 4 digits of their social security number. That had been written as part of the rulemaking procedure, but the request was to make that statutory. So that's what this does, is it moved it up. And then the rulemaking procedures are below, and it no longer includes that paragraph, but the rest are all from the bill. And there is a fiscal note required. So it will require a one-time general fund appropriation of $259,000 for contracted programming costs to implement this online voter registration process. So that's the majority report.
Thank you, Janet.
Here's that one page. Oh, it got scanned out of order. I do not understand why. So there is another page.
Okay.
Just to point out, there is a change in the effective date, which it was originally going to be January 1st, 2023, and now it's November 1st, 2023. And then Part B is stricken, which was a study that would have the Secretary of State study the way to get third-party organizations to maybe provide online voter registration, and the majority voted to remove that. So that's stricken. So again, I don't know why. I must have entered these into the copier out of order, so they scanned out of order. But all the pieces are there, in my defense.
Thank you, Janet. I guess if I can ask a question just on the fiscal note, if the Secretary of State's here. So is this to, I guess, is this on top of the, I guess, or is the online voter registration system going to be incorporated into the CVR? Or is it separate from that? Oh, maybe Deputy Flynn. It looks like Secretary Bellows may have had to leave. Oh, and you're on mute, Julie, sorry.
Sorry about that. I think I would learn. Old dog, new tricks, right? So there is a component that has to be developed as the online portal, which would consume the data and then pass it over to the central voter registration system for checking the integrity against the motor vehicle information and making sure the person's already registered to vote or not. And this cost was based on what some of the more recent developments were, because it is something additional to a basic central voter registration process. So those are just sort of the more recent cost estimates from other states.
Okay, thanks. Yeah, it makes sense. And seeing no other questions, sorry to interrupt, Janet, if you had, I think, another report on that one.
I did.
Okay.
So the minority ought to pass his amended report for Representative Corey is similar, but it does have some differences. So again, it has the technical fixes. It doesn't get rid of the Part A versus Part B because there is something else in Part B we'll talk about in a second. It still gets rid of the requirement that when you re-enroll after withdrawing, that it be in writing, because that can occur through the portal. It still moves the requirement about having to disclose your driver's license or non-driver ID number or the last 4 digits of your social security number. That's still going to be a statutory requirement instead of in rules. But this is one of the key differences in this minority report is there's rulemaking that's required to create a process where after receiving the online voter registration, the municipal clerk will send out a signature card to the online voter registration applicants and have them return that card. They have 60 days to do so. In the meantime, the signature that they have on file can be used as their voter ID signature. But if they do not return that signature card within 60 days, the next page shows that their online voter registration won't be effective because the signature card is required. Another major difference from the majority report is that online voter registration would not take effect unless the state enters into a membership with the Electronic Registration Information Center, which we sometimes refer to as ERIC. And that's a prerequisite to this online voter registration taking effect, although it can't take effect before November 1st, 2023, which is the majority report's implementation date. And that, I believe, had been a request from the Secretary of State's office related to obtaining the new central voter registration system. And then Part B of the original bill, remember, had that study about third-party organizations and online voter ID, and that voter registration, excuse me, and that's still being removed in this amendment, but instead it's adding the requirement that the Secretary of State conduct periodic maintenance of the voter registration rolls using the information from ERIC. Let's see, again, there's going to be a fiscal note, so there needs to be appropriation allocation section. This is slightly different, however, than the appropriation section you saw before. So there's a first year fiscal cost of $49,000, and that's for joining ERIC. And then this amount is increased over the amount that you saw in the majority report. So $259,000 is the cost that was in the majority report. That's going to be for creating that additional module in the central voter registration system. Then there's going to be a $24,000 cost associated with maintaining ERIC membership, and then $17,979 cost for printing and supplying the additional voter registration signature cards to the municipality. So that's a breakdown that I got from the Deputy Secretary, and she's here to ask more questions if you want to about that, but that's what this total is comprised of. There is an issue, though, to talk about with this minority report. So because it requires municipal clerks to send out the signature cards, it was flagged by the fiscal office as a potential state mandate. And we don't talk about that a lot, or we haven't talked about potential state mandates a lot in this committee yet this session. So although I'm sure Representative Corey, and this is his report, knows about it, just to remind everyone else on the committee, when you have a potential state mandate, if you agree that that is a new duty upon the municipality that will increase their costs, so it's a two-part test. Is it a new duty and is it an increase in cost? Then you have a couple of options of what you can do. You could add the mandate preamble, which would require a 2/3 vote of each chamber to pass the legislation. You could instead choose to add funding for 90% of the cost to the municipality. So that would add more of a fiscal note to the bill, or excuse me, to the amendment. Or you could do nothing, even though you might agree it's a mandate, in which case, if there's ever a challenge, a municipality could say, we are not obligated to engage in this additional activity because it was not funded and it was not voted out within a mandate preamble. And a court would look at it and decide, is this a mandate or not? And if they decide it was a mandate and we've done nothing, then they would decide, yes, the locality is right. It's not obligated to follow this statute. So that is an option. And the final option, although I listed it as number 3 here, is if you disagree with the fiscal office flagging this as a potential mandate, you could direct me to put in the summary of the amendment why you disagree that this is a mandate, and give an explanation. It would still ultimately be up to a court to decide if the legislation passes without the mandate preamble, or the AFA committee, if this is placed on the special appropriations table, also could disagree with you and say, no, we do think it is a mandate and we're going to add the mandate preamble ourselves. So there are several ways to move forward with this, but because of the additional requirement to send out those signature cards, it was flagged. And so I need some direction from the minority report about what to do with that potential statement.
And Janet, is this, I didn't hear it. Is this just a one-person report?
Yes, sir.
Okay. And that's Representative Corey. Gotcha. Oh. Did Representative Corey freeze? Oh, no, there he is. Okay. Gotcha.
Great. I feel like I'm doing the committee's best work in one-person minority reports this year.
I'm sure the production offices love it.
So I am, I'm gonna go at fund at 90%.
Okay.
Thank you.
May want to get working on those thank you cards too.
This is exciting. I've never done a fund at 90% one, so now I'm going to get to learn how that works. I know that's not why you did it, and I wouldn't ask you to do it for that reason. I just thought I'd tell.
Do we have one more or?
We do have one more.
Okay.
I'm just really slow today.
No, you're not. A lot of different divided reports.
My mind is not switching between tasks easily. Okay, so the next one is a unanimous ought to pass as amended report for LD 1485, which is an act to modify the requirements for political action committees and ballot question committees. If you remember sort of the general overall theme of this bill, which was submitted by the Commission on Governmental Ethics and Election Practices, the overall theme was to clarify the difference between PACs and ballot question committees and make it clear that PACs are involved in candidate elections, in influencing candidate elections, and ballot question committees are involved in initiating and influencing ballot question elections. But when I looked at, there were some things that you voted for as unanimous amendment, but then when I also looked at the text of the bill and where everything was written, it became clear that it made sense to reorganize the way that the bill was drafted, to put everything about these committees in the substantive provisions of the statute that involve these committees. So hopefully this will make sense in a second. So one of the things you directed the amendment to do was to clarify in the overall general definition section, which is in section 1 of Title 21A, that ballot question committee and political action committee mean the definitions that you're providing through this bill. They had different cross references and those needed to be fixed. So that's what section 1 and section 2 of the amendment do. Another thing you asked was that the definition of leadership political action committee, which had been proposed in a different ethics commission bill, be incorporated in this bill instead. So this is the definition of leadership political action committee that you all settled on. So it's a PAC that's not a caucus PAC, that's directly or indirectly established by a current member of the legislature, or that is directly or indirectly maintained or controlled by a current member of the legislature. And it's written this way so that if it was established by someone who's part of the legislature who then leaves, it's no longer considered a leadership PAC. So former members of the legislature aren't going to be triggering the leadership PAC definition. It's only current members of the legislature who trigger that definition. And although we don't yet have it for amendment review, LD 1417 also has a definition, and you directed me to make sure the definitions stayed the same as each other so they wouldn't create a conflict. So I have been keeping my eye on that, and that should be true, depending on what you do with this bill today, I suppose. Then the original bill had gotten rid of the separate segregated fund variation of a PAC, and this is being added back. So it looks like you're striking out separate segregated fund, but what this says is get rid of the strikeout. So you're adding it back, even though it looks the opposite. That's a little bit weird about the way they have to print amendments. So I just wanted to make that clear to you. But when you're a separate segregated fund of a corporation or a labor organization, you're only going to be considered a PAC if you receive contributions or make expenditures aggregating more than $2,500 in a calendar year, because that's what the bill does, uses as the PAC definition. So it's going to match. The next thing, if you remember, you wanted to add the leadership PAC definition, but you can't add a definition to a bill if you don't actually use that defined term somewhere. And you had directed me to work with Director Wayne on making sure that the way that this amendment was written worked. So we cobbled together a way to use this phrase. And we said that when the PAC is registering, that it would have to self-identify as a leadership PAC. And that way you've now used the phrase and it can now be defined in the statute. I know that there's another bill that actually has requirements about leadership packs, but that's not included in this bill. So each bill has to be looked at on its own. And so because you're defining the phrase somewhere through this bill, you have to use the phrase. So that's why we put that in there. That isn't what you voted on. So I did want to point it out to you, but hopefully you don't view it as problematic. It's just required to use that phrase somewhere. The next part, there was a part in the bill that talked about appointing a treasurer and having a segregated campaign account. And you had agreed to making some technical changes to that language to make sure it matches the defined phrases in the statute. So that's all. I circled the words that have been changed to make sure they match defined terms. There also had been some exceptions to the segregated account requirement for certain individuals who have ballot question committees, and there were rules that could be adopted. So this is specifying that those are routine technical rules. And then there's another provision of law. I think this is the record keeping requirement where there had been some rules that the Ethics Commission could adopt about exceptions. And again, you wanted to specify that they're routine technical rules. So those are what these portions of the amendment do. As far as the content of the reports, you had directed me to work with the director to make another set of technical changes to make sure that the language matches all of the defined terms. So that's what these provisions do. They don't change the substance of those provisions of the bill. And all this part is the same as the bill. They just kept reprinting it because there was also a technical change here. The original bill said payments made from the segregated campaign account. And we took out that word. So because there were amendments throughout this section, they just reprinted the whole section. The last part of the amendment was something new that you directed to include in the amendment, which was if you look in the Maine Clean Election Act, where it tells Maine Clean Election Act certified candidates or those seeking to participate in the Maine Clean Election Act who haven't yet been certified, that they can't establish certain types of political action committees. And now that the definition of political action committee, if LD 1485 as amended is enacted, will no longer include any type of ballot question committee, the language below that says, oh, but you can form a ballot question committee, it's no longer necessary because they're not being prohibited from doing so when you just use the phrase PAC, now that that phrase is newly defined in the bill. So this is just a cleanup that you asked us to include in the amendment, so it's there. There is a required fiscal note, but it's just a minor cost increase fiscal note that you can see here.
All right. Thank you, Janet. Any questions, concerns from anybody in the committee? I think this was unanimous, right, if I recall?
Yes.
Yeah. And I know we heard from Director Wayne. He can't be here today, but he expressed his agreement with the language, I believe.
Yeah, and you had directed me to work with him, so he
Yep.
had seen it all along.
Yep. Any questions from the committee? Okay, seeing none. Is that the end of our language reviews for today, or for this morning, or for right now?
I suppose I will let you off the hook now. Yes.
Okay, great. Let's then move on to, when you're ready, Janet, 1726, I think that is President Jackson's bill, right?
Correct. I'm just moving it onto my screen so I can share it. So despite the fact that this is being broadcast on YouTube and it's highly embarrassing, I must say that although I understood the testimony on what the bill was attempting to do, I found it very difficult to read the bill the way it is drafted. So I hope that I'm not annoying you or making you think I am for or against the bill. I literally think that the way it is drafted is very confusing. So, oops, that's the wrong one. So hopefully you all can help clarify that and maybe allow me to redraft it if some of you want to vote in favor of it, because I think it could be written a little bit clearer. Although probably when I try and draft it, I'll see how difficult that is, and then I'll be saying mea culpa. So this bill appears intended to provide that if a communication is in the guise of news and otherwise meets the criteria of section 1014, subsections 1, 2, or 2A of current law, which I'm about to explain, or if it is internet or email activity costing less than $100, and it is published or paid for by an individual who isn't required to file campaign finance reports with the commission and who is employed by a candidate, candidate's authorized campaign committee, a party committee, a PAC, a ballot question committee, or an agent of one of those. So if all of those things are met, then the communication must include the statement paid for by, and then you would insert the name of the employer. Because remember, the individual has to be employed by one of these entities, so that's the name you would insert there. If the communication is a printed email or internet post communication, the statement must appear at the top of the page in capital letters and at least 12-point font, or bold font, excuse me. So let's understand current law, maybe a review of that for purposes of understanding how this works. So under current law 1014, which is attached to the bill analysis, if you happen to print it out, you can follow it along there. Or if not, it's hyperlinked here if you're following along at home. So under current law, when a person makes an expenditure to finance a communication is defined as through broadcasting statements, cable TV systems, newspapers, magazines, campaign signs, or outdoor advertising facilities, publicly accessible sites on the internet, direct mailings, or similar types of non-periodical publications. So if someone makes an expenditure to finance that type of communication, and that communication expressly advocates the election or defeat of a clearly identified candidate, or names or depicts a clearly identified candidate, and is disseminated in the short time frame before the election that's set forth here, then that communication has to state the name and address of the person who financed the expenditure. This is sometimes referred to as the attribution requirement. And it must also clearly and conspicuously disclose whether the communication was authorized by the candidate's authorized political committee, or their agents. That's sometimes referred to as the disclosure requirement. So if you have a communication through these types of media, expressly advocating the election or defeat, or naming or depicting the candidate in that short time frame before the election, there's both the attribution and the disclosure requirement. Under current, there's also a broadcaster and newspaper duty, which I mentioned because the bill amends that section in a way that I'm not clear what it intends to do. So that would be helpful to remind you. There's a broadcaster and newspaper duty. So broadcasting stations, cable TV stations, and newspapers, which are defined as any printed material intended for general circulation or to be read by the general public, including a version of the newspaper displayed on a website owned or operated by the newspaper. So if any of those entities publish a covered communication and it doesn't include they're not allowed to publish that type of communication unless it includes the attribution and the disclosure that are required to be part of the communication. So the duty is both on the person making the communication and the person publishing it if they're a broadcasting station, cable TV station, or a newspaper. There's a penalty in current law. So a person who violates these requirements, including the broadcaster and newspaper, is generally penalized by a fine of up to 100% of the cost of the expenditure. In assessing the penalty, the Ethics Commission is directed to consider how widely the communication was disseminated, whether the violation was intentional, and whether the identity of the person who financed, not financed the penalty, but financed the communication was concealed. The commission may waive the penalty if the person who committed the violation corrects it within 10 days of receiving notice of the violation. So those are the general attribution and disclosure requirements of current law. There are some relevant exceptions that you may or may not want to apply to the bill before you that I thought would be helpful to explain. So under current law, internet and email activities that cost no more than $100 and that are produced independently by individuals who aren't required to register or file campaign finance reports with the commission, and who are acting independently of and without authorization by a candidate's authorized campaign committee, party committee, PAC or ballot question committee, or an agent of those. Those all do not have to include an attribution or disclosure on them. So I've just sort of restated this here. Accordingly, the internet and email activities exception does not apply. So you will have to make a disclosure unless the individual who made the expenditures is acting independently. The rules adopted by the Ethics Commission explain that an individual is not acting independently of and without authorization by one of these persons if the individual's activities are suggested, requested, directly or indirectly authorized, compensated, or reimbursed by one of these persons. So this exception for these internet and email activities costing no more than $100 is not all that broad, because it really depends on who you are if you're engaged in these activities and whether you have any sort of association with or coordination with one of the identified types of candidates or committees. And those are all the same types of candidates or committees referred to in the bill itself with this new paid for by disclosure requirement. There's also a press exception to the current attribution and disclosure requirements. And the reason that exception exists is because under current law, you only have to attribute who a communication is made by and disclose whether it was authorized by the candidate if an expenditure was used to finance that communication. An expenditure is defined to exclude any news story, commentary, or editorial distributed through the facilities of any broadcasting station, cable TV system, newspaper, magazine, or other periodical publication, unless the facilities are owned or controlled by a political party, political committee, candidate, or spouse or domestic partner of a candidate. So if it is a news story and it's not owned by or controlled by one of these entities, then the fact that it was published is not considered an expenditure, so the attribution and disclosure requirements don't apply. There are Ethics Commission rules about this press exception. And so by rule, to qualify for the press exception, the names of those who own, control, and operate the station or publication must be identified within the publication or made known to the public. And the station or publication can't be owned or controlled by all of these parties and committees, so a party, PAC, or ballot question committee, or there's a little more detail here, it can't be owned by a candidate, candidates committee, or family member of a candidate if the news story involves that candidate's candidacy or their opponent or their campaign. So it's a little more flesh to this ownership requirement for it to qualify as an expenditure. The rules also further describe the types of periodical publications, including internet publications and websites that qualify for the press exception. So in order to have this exception and to not be required to disclose whether it's associated, authorized by a candidate, and to not be required to state who financed or made the communication, it has to meet these qualifications if it's an internet publication. It must have been disseminating news stories, commentaries, or editorials on a variety of topics to the general public on a periodic basis for at least the previous 12 months, or it must have a record of disseminating news stories on a variety of topics to the general public, or there must be other objective indicators that the publication will continue to be published on a periodic basis beyond the election cycle during which the press exemption is claimed. So accordingly, if a website appears to be a news website, but it doesn't disclose the names of those who own, control, or operate it, or it is owned or controlled by one of the entities that are prohibited in this list above, or it is a website that doesn't meet this periodical publication requirement, then the attribution and disclosure requirements of current law do in fact apply to that website. And I'm telling you this not because I don't think you can't have a bill that adds a new requirement about the paid for by, but it's just that it's very tricky about whether something meets the press exception requirement. And it's worth noting, although I mention it later, that the word expenditure is not actually used in the bill. So it's not clear to me whether this press exception and all of these requirements are supposed to apply to the bill because that word is not used. So I thought it's worth you knowing what the contours of it are so that you know whether you want it to apply or not. There is another exception in current law when we look at the word expenditure. Remember that word expenditure is used for the attribution and disclosure requirements of current law. So expenditure is defined to exclude compensation paid by a state party committee to its employees for the following purposes, and that includes providing no more than a total of 40 hours of assistance from its employees to a candidate in any election. So as I read that exception to the definition of expenditure, if the only cost associated with a communication that would otherwise be required to include attributions and disclosures, if the only cost associated is the party's payment of its employee who spends less than 40 hours preparing communications for any single candidate, then the attribution and disclosure requirements of current law do not apply. So that gives you the background on the way current law applies and the way expenditure applies. If you want that to be part of this bill, and as I said before, it's not clear whether that expenditure requirement is part of the current bill, just so you have that information when you decide how to move forward. So some issues for consideration. I drafted most of this before seeing Director Wayne's additional testimony, and some of these issues were raised by others in the work session. In the public hearing, and some weren't. As you can tell, it was late at night because I can't keep my numbers straight. But the first question is, what does it mean for a communication to be in the guise of news? I believe this was raised also by Attorney Brodigan, but that might be helpful for you to pin down. Representative Corey raised the question about the font specification. So how can font size requirements apply to an email or an internet post communication, especially given the varying sizes of the devices used by individuals to view such communications? The font size requirements also apply to written communications, so perhaps that is easier to understand, but it is difficult to understand in the internet and email context. There are some issues about whether the disclosure required by the bill has to actually be true. And this is also something that Director Wayne raised as well. So the bill requires disclosure of the employer of the individual who made or paid for the communication. So for a communication to be covered, we're talking about an individual who made or paid for that communication being employed by a candidate, candidate's authorized campaign committee, party committee, PAC, ballot question committee, or an agent of one of those. But it's not clear to me whether the bill is intended only to require that such a communication say paid for by, insert name of one of these employers, if it's accurate. So for example, if an individual is employed by a ballot question committee, for example, or maybe a party committee, and they submit an internet post about a particular candidate race so that it covers, it comes under the requirement that it be express advocacy or naming or depicting a candidate within a short time frame before the election. But their employer, either the ballot question committee or their party committee, had no knowledge of the internet post, didn't compensate them for their time spent drafting the posts, and didn't approve the posts. Must those posts still say paid for by either the ballot question committee or the party? As I read the bill, they would have to state that. But I admit, like I said at the outset, it's very difficult for me to follow the way the bill is written. So that's something for you to consider, whether you want that disclosure to be required if all of those circumstances are true. At the public hearing, we heard some concerns that there may be some First Amendment issues involved. I think the most obvious First Amendment is that to the extent this bill compels individuals to make false statements about who paid for a candidate. So for example, perhaps in this circumstance, it's unlikely to survive a First Amendment challenge because the First Amendment challenges, as we're about to discuss, the justification for requiring compelled disclosure is to provide information to the voters and make it less confusing. But if you're compelling people to make a false statement, it's very difficult for the states to say that that's so that it will be less confusing and clear to the voters. But to the extent that the bill only compels individuals to make true statements, so only to say paid for by the employer if it actually was paid for by the employer, there is a tension between two distinct lines of Supreme Court cases that makes it difficult to predict precisely who can be required to make these disclosures. So to the extent you want to discuss which people should be involved and which people should be required, it's important for you to understand this tension between the cases. So there is a line of cases, including most recently the Citizens United case, that talks about disclosure requirements. So although the First Amendment has its fullest and most urgent application to speech uttered during a campaign for political office, there's a quote I've said to you many times, campaign contribution and expenditure disclosure requirements frequently survive First Amendment challenges because they impose no ceiling on campaign-related activities and do not prevent anyone from speaking. The government's interests in avoiding public confusion by clarifying whether communications are funded by a candidate or political party, and in protecting the public's interest in knowing who is speaking about a candidate shortly before an election, are generally considered by the courts to be sufficient to support these types of disclosure requirements. Specific individuals and organizations may nevertheless succeed in demonstrating that a particular disclosure requirement is unconstitutional as applied to them personally, however, if there is a reasonable probability that the individual or members of the organization would face threats, harassment, or reprisals if their names are disclosed. So that's important to understand. That second piece is that even if a law might be generally fine and viewed by a court as generally constitutional to exist, there still can be individuals who can go to court and say that law should not be applied to me. And if they provide this type of proof about harassments and threats and reprisals, then a court may exempt them from the law's requirement. It doesn't mean they'll strike down the law entirely, but they may exempt certain groups or individuals if they have that sufficient proof. On the basis of the logic that the Citizens United case provided about generally disclosure requirements are okay because they provide information to the public that it might need to know who's speaking about the candidate shortly before the election. On that basis, the National Organization for Marriage versus McKee case from the First Circuit in 2011 examined the disclosure and attribution requirements in Section 1014, which we discussed before, although it was the 2011 version of the law, and it has been changed slightly since then. But it described the burden imposed by those as minimal because it required only a statement of whether the message was authorized by a candidate and a disclosure of the name and address of the person who made or financed the communication. So that's the disclosure line of cases. There is, however, the anonymous speech line of cases, which is best exemplified by the McIntyre case from 1995. In that case, just as a little background, Mrs. McIntyre was a woman who disagreed with a local question that was about school funding, I believe, if I remember correctly. And so she was handing out pamphlets outside of school board meetings. And sometimes the pamphlets had her name on it, sometimes they didn't. And she was in trouble because of an Ohio law prohibiting anonymous campaign literature. So in McIntyre, the US Supreme Court concluded that the Ohio law prohibiting the publication or financing of anonymous public communications expressly advocating the election or defeat of a candidate or a ballot measure was unconstitutional. The court began with a proposition that an author's decision to remain anonymous, like other decisions concerning omissions or additions to the content of a publication, is an aspect of the freedom of speech protected by the First Amendment. It may be interesting to you, although I didn't want to clutter up the bill analysis by writing about it. The Supreme Court went through the history of anonymous political publications, including the Federalist Papers themselves, which were written under fictitious names, to highlight how important this anonymous literature right was and protected by the First Amendment. And also to point out to you, although I didn't put it in the bill analysis, how strongly the Supreme Court felt about this. Mrs. McIntyre actually died before the case went to the Supreme Court, and ordinarily that might be a reason why they would decline to accept the case, but they said that the First Amendment rights were so important that they were going to keep the case and decide it despite the fact that she had already died. So in that case, although Ohio had argued that the law was supported by its legitimate interest in providing voters with relevant information, the court noted that the law swept too broadly for several reasons, and there were other reasons, but most relevantly here, including that the law applied to private citizens like Mrs. McIntyre, who acted independently of any campaign and its organized supporters, and whose name and address would add little, if anything, to the reader's ability to evaluate the document's message because she wasn't really a public figure and well-known. So there is that tension. The Citizens United case doesn't talk about McIntyre at all, so it doesn't overrule it or anything like that. There are different court cases across the country, recognizing the tension between these two lines of cases. And there have been law review articles and different professors who know far more about this than me, who've written about this tension, including there's been a court case in Maine that acknowledges this tension. So in Bailey versus Maine Commission on Governmental Ethics and Election Practices, the U.S. District Court for the District of Maine acknowledged the tension between McIntyre and Citizens United. But in that case, it held that the disclosure and attribution requirements that we just previously discussed that are in 1014 of Title 21A of Maine law could constitutionally be applied to the plaintiff in that case. And that plaintiff had created a website expressly advocating the defeat of a gubernatorial candidate shortly before the general election. Although that plaintiff acted alone when he posted the materials to the website, he had the assistance of the husband of one of the candidate's primary opponents in gathering the content for the website, and he was working for another opposing candidate when he created the website. Yet, when created, the website stated that it was made by a group of researchers, writers, and journalists not authorized by or affiliated with any candidate or political party. So in light of these factors, the district court in that case concluded that the state's interest in an informed electorate is near its zenith, where a widely viewed website falsely claiming to be written by journalists unaffiliated with any campaign expressly advocates the defeat of an opposing candidate shortly before a statewide election. So when you have all of these factors, a court finds it not difficult to decide that the McIntyre case isn't a problem and that the Citizens United line of disclosure cases saying that the state's interest in informing the electorate about who's speaking about candidates right before an election are sufficient to require the attribution and disclosures to be on a website in that kind of situation. But I think what the people at the public hearing were referring to was the fact that there are people like Mrs. McIntyre out there in the world who aren't acting in association with any kind of candidate or campaign or any kind of committee, who just want to get their word out. And the Supreme Court has said that their right to remain anonymous is a strong enough right to decide a case even after they die. So it doesn't mean that the bill has anything to do with the Mrs. McIntyres of the world, but to the extent that you want to discuss who the bill should cover, that is worth you knowing about. And then the Maine Association of Broadcasters, they had wanted to be part of the hearing, but they had to leave before their turn came up. And so they submitted written testimony, basically saying that they'd hope that broadcasters don't get swept up in the bill's disclosure requirements. Now, as far as admitting my inability to understand the way the bill is written, it is not clear to me what section 1 of the bill is doing. And that's the part of the bill that says that newspaper, for purposes of the requirement, in existing law for the attribution and disclosure requirements, it says that newspaper doesn't include a communication that's covered by the bill. I'm not sure exactly what that's intended to do. In addition, the language of section 2, which is the heart of the bill, is ambiguous in several respects, and it may be helpful for you to consider. First of all, there was the first question I already asked, which is, what does in the guise of news mean? That seems to be the most important question. But then once you decide that, is that in the guise of news requirement intended to apply to internet or email activity costing less than $100? It's not entirely clear from the way the bill is written. In addition, remember, the bill says that it applies to either those internet or email activities or other communications that otherwise meet the criteria of 1014 subsection 1, 2, and 2A. It's not clear which criteria is intended to be imported. Is it just the type of media, whether it's internet or broadcasting or yard signs? Is it also supposed to include the contents and communication? So does it have to be express advocacy or naming or depicting a clearly identified candidate shortly before the election? Or is it intended to include also the requirement that it be paid for by an expenditure? If it does include that expenditure requirement, remember, then you have the press exception and you have the exception for party employees working no more than 40 hours for any specific candidate. So it's unclear to me, is all of that intended to be tied into this paid for by new disclosure requirement? In addition, which portions of these requirements, if any, are supposed to apply to the internet and email activities provision of the bill? I think it was meant to say that if you're an internet or email activity costing less than $100, but you nevertheless meet these requirements, then you need to say paid for by. That seems to be, if I read the sponsor's testimony, I think that's what it was meant to do. I don't think that's actually what it does. So if you want it to do that, just tell me and we can try and redraft it that way. And then we don't yet have the fiscal impact. So I'm sorry for being so confused by the bill, but hopefully you have the information you need to make some decisions on it.
Thank you, Janet. Oh, sorry, Chairman Kasdan. Okay, whichever. Thank you. I think in the hearing, we heard from the testimony, there were a lot of concerns around First Amendment stuff, and that analysis is really helpful. And also, I had to step out for a minute there, but we also did get additional testimony from Director Wayne in the Ethics Commission, which they're in a big commission hearing today, so they aren't able to be here, where he advised that we reach out to the AG's office if we're planning to move forward, and perhaps they can help us if people wanted to move ahead with the most defensible version of this bill. But those are just some thoughts from my perspective. I think hearing from the AG would be important before I'd be comfortable voting this. And if we don't have time for that, then I'm not sure I'd want to move ahead. Representative Chiazzo.
Thank you, Mr. Chair. I guess that would be my concern. I mean, we're just getting this with literally 2 days left of committee. And it sounds like there's going to be some concerns and questions about it. So I don't know if we, maybe we want, I'm not making this as a motion, but perhaps we put this aside until Friday to see if we have the bandwidth to process this. And if not, we can move it over to the next session, but I'm not so sure we'll have time to get this done, as well as all of our other outside remaining committee work in the next couple of days. That would be my concern.
Right. Representative Corey.
Thank you, Mr. Chair. I have huge First Amendment, concerns, with this bill, and I don't know how we work our way around those. I mean, I personally, I don't like it when, a 501c4, comes into, my district, reaches out to my constituents, obviously, is advocating, against me, in election years, and at the same time, is hiding, behind that 501c4 designation, where a lot of the principles of those organizations, if I really, painfully go and try to figure out, who the organizations that are contributing to that organization are, and those principles, they don't put their names on those communications or whatever. They're hiding, behind it, and they're doing it in the name of news. Now, I know that as much as I don't like that personally, right? It's protected. It's protected, speech, as is this. If people aren't expressly advocating, for the election or defeat of a candidate, I don't know how we do this. We have campaign finance laws that talk about disclosures when people are expressly advocating. And, as Janet said, and going back to the Federalist Papers, anonymous speech is protected speech. So I'm going to move an ought not to pass.
We have a motion of ought not to pass by Representative Corey.
Second.
And seconded by Representative Kinney.
Mr. Chair, do we have a quorum?
We don't at the moment. No, we can't vote until we have a quorum. Further discussion. Representative Chiazzo.
Thank you, Mr. Chair. I agree on the surface that there clearly are some constitutional issues with this, but I think also based on Janet's analysis, there are ways, there are potential mechanisms for us to try and require disclosure requirements. And while I agree that for many people, well, I can agree in principle that speech that, I'm blanking out on the name that, but anonymous speech. Thanks. Sorry. Anonymous speech is certainly something that's covered under the Constitution. I do feel like, if at all possible, people need to understand where the source is coming from and who's making those claims, whether they're fair, foul, right, wrong, whatever they are. Because I think otherwise, free speech is critical. It's important, but shouldn't be at the detriment of truth and other things. So I'm a little hesitant to just blow this one up and say no. I think it requires, from my perspective, a little more thought and discussion. Certainly it's complex and complicated. I think we need to get the AG involved and get opinions across the board like we do with every bill. My concern would just be the timeliness of introducing this bill now, this late in the session. It happens, but we do have a vehicle to continue this conversation, which I think should be warranted and give this bill the due process that it deserves. So I'm not going to support the ought not to pass motion.
Thank you, Representative Chiazzo. Yeah, I agree. I don't generally just try to kill a bill because it's hard to think about, immediately. The director of the Ethics Commission gave us some suggestions actually on how we can do this, because I think this is a problem that's becoming bigger and bigger as we, especially through social media, and I'm sure both sides of the aisle do it. So I don't think it's a particularly partisan thing, but disclosures for people who are trying to impact an election, we've seen that is appropriate if, especially if that's the reason that it's doing it. And I'm sure both sides of the aisles probably are doing this type of stuff. Representative Corey.
Yeah, I want to make it sort of very, very clear that, I did not move an ought not to pass motion because I feel like this bill is difficult to work with now, especially at the end of session. I'm perfectly willing to do the hard work, on any bill or any amendment, to a bill. My concern here is, again, that, I think that there are huge free speech issues. I think that if we want to address the concerns that are put in this bill, there's a heck of a lot more areas this is happening than, online news sites and everything else. I think with regard to things that are directly there to impact elections, we certainly have those laws, and that's where, our laws with regard to expressly advocating, come into place. And if somebody is expressly advocating the defeat or election, of an individual, and they're using a site to do it, they do have to disclose. That's what our laws in Maine say. So, I think that this is taking, trying to take care of something that's one covered, within the Constitution. And I think we'd be looking at a First Amendment, challenge. And two, I think if we're going to do this, we have to take it all on. We have to take on the 501c4s. We have to take on, all of the people doing this kind of stuff. But it's not about, feeling like we're running out of time in the session.
Gotcha. Yeah, and as I said, I have no problem if we can't get any clarity to take it, not to pass it, but I think it's worth doing a little bit of research with the AG's office. Any other discussion? 1, 2, 3, 4, 5. No, 1, 2, 3. Okay, we have a quorum. Representative Chiazzo.
Thank you, Mr. Chair. I make a motion to table, please.
Second.
Motion to table by Representative Chiazzo, seconded by Representative McCray. Okay, tabling motion is non-debatable. So Karen, if you please, can you please call the roll?
Senator Lucchini.
Yes.
Senator Lucchini, yes. Senator Hickman. Senator Hickman, absent. Senator Farren. Senator Farren, absent. Representative Chiazzo.
Yes.
Representative Chiazzo, yes. Representative McCray.
Yes.
Representative McCray, yes. Representative Tuttle.
Yes.
Representative Tuttle, yes. Representative Riley.
Yes.
Representative Riley, yes. Representative Supika.
Yes.
Representative Supika, yes. Representative Wood.
Yes.
Representative Wood, yes. Representative Kinney,
Reluctantly, yes.
Representative Kinney, yes. Representative Harrington, Representative Harrington, absent. Representative Corey,
I feel the same way as Marianne, so yes.
Representative Corey, yes. Representative Dalla,
I'd like to say no, but I'll go with everybody else and say yes.
Representative Dalla, yes. 10 in favor of the motion, 0 opposed to the motion, and 3 members absent, Mr. Chair.
Thank you, Karen. So we'll pick this up again Friday, and Janet, if you don't mind reaching out to the AG's office just to get thoughts. And again, if it's an extremely short turnaround for them too. And if they can't do it, then I'd be fine to either kill it or send it over to the next.
We'll ask for input by Friday on whether as drafted it's got issues, or what exactly did you want me to ask?
I guess some of the issues raised by the Ethics Commission, I think the Ethics Commission and the AG's office kind of work together on
Gotcha.
these type of things. Yeah, so I guess both of them together, I think they've helped us with some other issues just on I think Director Wayne's testimony laid out some of the big concerns, as well as the issues raised in the analysis.
Certainly. Thank you.
Okay, and I had to step out, so have we gotten to LD 451?
Not yet.
Okay. Okay, so LD 451 is an act to remove the party designation from return envelopes for absentee ballots for the general election. This is one that we've, sorry, go ahead,
I
Janet.
just wanted to give you an update on that. So if you recall, there was an identical bill, LD 456, that was voted out not to pass. And then the text of this bill was added to the majority report to LD 148, which was the Speaker's ongoing absentee voter bill. I would point out that LD 1363 has a majority report that amends the same section of law to provide that absentee ballots need not be issued until after the official ballots become available. So if you remember, the law says that once somebody's application for an absentee ballot is accepted, the ballot needs to be immediately issued, but ballots can be submitted up to applications can be submitted up to 3 months in advance and the ballots aren't ready yet. So 1363 has language which is amending the same provision of law as section 2 of 451. And it talks about not having to issue them immediately, but only after the ballots become available. So both that piece of 1363 and this requirement that the return envelope not have any indication about the political party of the voter during a general election, both of those pieces are in the majority report to 148, which again is the Speaker's ongoing absentee voter bill. Just so you know where all the pieces are.
Okay, thanks. And we had kind of held this one just because I know we just wanted to keep it on for people who wanted to see it passed in some way. And obviously we haven't gotten through it with 148 yet. So it's still kind of in that limbo position. Representative Kinney.
Thank you, Mr. Chair. I was just going to kind of go along that line. We don't know for sure whether or not 148 or 1363 are going to pass. Would the committee be willing to carry this over just in case that doesn't happen and then do a not to pass if it does pass in the first session?
Yeah, I'm open to that. Or if people want to, I mean, we could also vote it, I guess, and then whatever option we could vote it and then just table it for a while, or carry over may be the easiest way actually, in case that other one, it's so weird where we're not in session that frequently and we only have 2 more days. So I'm fine to carry it over if people want to.
Yeah, if I may, I'm concerned about the idea of if we pass this and then what does that do to statute if we pass this in multiple bills? Do we have the language written properly so that it really doesn't make multiple additions to statute? But I'd be just as happy just carrying it over if that would be okay with the committee. And I'd be willing to say I make the motion to carry over LD 451 if that's helpful.
Sure. So a motion to carry over LD 451
Second, Mr. Chair.
by Representative Kinney, seconded by Representative Tuttle. Discussion on that. Like I say, I'm fine to do that, and we'll be able to see the fate by then. And yeah, Representative Tuttle, were you?
I was correcting myself, Mr. Chair.
Were you? Okay. Okay, the motion before us is to carry over LD 451. Okay, we've got a quorum. Any further discussion? Seeing none, Karen, would you please call the roll?
Senator Lucchini, excuse me, Senator Lucchini,
Yes.
Senator Lucchini, yes. Senator Hickman. Senator Hickman, absent. Senator Farren. Senator Farren, absent. Representative Chiazzo.
Yes.
Representative Chiazzo, yes. Representative McCray.
Yes.
Representative McCray, yes. Representative Tuttle.
Yes.
Representative Tuttle, yes. Representative Riley.
Yes.
Representative Riley, yes. Representative Supika.
Yes.
Representative Supika, yes. Representative Wood.
Yes.
Representative Wood, yes. Representative Kinney.
Yes.
Representative Kinney, yes. Representative Harrington. Representative Harrington, absent. Representative Corey.
Yes.
Representative Corey, yes. Representative Dollop.
Yes.
Representative Dollop, yes. 10 in favor of the motion, 0 opposed to the motion, and 3 members absent, Mr. Chair.
Great. Thank you, Karen. And I think we're still well below the allowable or whatever carryovers limit. So we should be fine, I would think. But we've got a ton of bills.
So far, Mr. Chair.
Yep. Okay. So I guess, we've done 619, 1496. Is that?
That's correct. That's the one that's left. We have had a work session on this before. I didn't know if you wanted me to go through any pieces about like technical issues or anything else. I'll take your lead.
Right. Thank you, Janet. This one is, this one's Representative Kinney's bill, I believe, and maybe similar to the minority report previously. I wasn't sure. Representative Kinney, did you have a preference how we go?
Thank you, Mr. Chair. My thoughts with this one, where the audit piece on the other bill in the minority report is covered there. What I wanted to see happen with this was the ability for recounts to occur in portions of districts. So if there was an issue, for example, where someone wanted to recount part of CD1 or part of CD2 or part of a statewide race, Senate, gubernatorial, the US Senate or gubernatorial race that are statewide elections, to be able to look at maybe a community that they think was an issue and be able to start with recounting there rather than pushing for a full recount, so that you're not necessarily having to collect ballots from everywhere yet to do the recount, and you could just do a portion of it to start. And then if things start to look not quite right, then you can go to a full recount after that, but give it the opportunity to start with a smaller portion.
Thank you, Representative. It looks like we have Deputy Flynn in. I don't know if Deputy Flynn, if you can hear us. Oh, there you are. are there abilities to do partial recounts, I guess, now, or I know, or yeah, go ahead, sorry.
Well, I think a candidate can concede a recount once it's started at any point, as long as they have not taken over the lead. You know, if they surge ahead, if there's an error found or some reason turns it over, then you can continue to the end. We certainly do listen to the requesting candidate about which jurisdiction we start with. In some cases, we've had candidates say, I'm really only interested in these towns, and if things don't go my way, I won't continue. The problem is, I think the way the law is written right now, we do need to bring all the ballots for anything less than a statewide race, or a countywide race. So Senate and House or county commissioner, we'd bring all the ballots in, and that way, you know, if something did happen, then you've got them all there and you continue on and finish it and make sure that if the result changed in the, you know, after counting just the ones they were looking at. So I think you'd have to amend the law to do what you're suggesting. Although in practice, I mean, we get the ballots from the whole district and then begin with whatever the trailing candidate wants to look at first. I will say we have limited in our rules. We no longer get all the other materials unless the vote difference is fewer than 10 votes. Because generally, if it's a bigger margin and the result stays the same, we're not looking at voting lists or absentee envelopes. We're just looking and counting the ballots. And obviously, if something changed and a result did get within 10 votes, and we go back and get those other materials. So that does save us, you know, some cost in retrieval and not having to get all the other materials, you know, along with the voted ballots. The rules now with a statewide recount, we do it in stages. So we are not going and getting all the ballots from the state, because it's designed to, you know, start with the largest district, the largest turnout towns, count those, give the requesting candidate an opportunity to say, you know, I concede, or no, I want to go on, and then we get the next grouping of towns, and that's laid out in the rules now for statewide races. So we're limiting the cost, because with a statewide race, the candidate, or if it's a ballot question, the ballot question has to pay for the entire cost. So we're doing it in a tiered way in order to limit the cost to the requesting candidate. But then, you know, obviously it's up to that person to say, yeah, I want to go on, because it's maybe the lead is narrowing or something.
And so, Deputy, during those tiers on a stages recount, I remember you kind of talked to us in the past. You do take input from the candidate as well?
Yes. We did start, when the last time we did a statewide ballot question, we did, I think it's worded in such a way that we take the top 10% of the votes, so that we're not just taking a town and then you got to go back and wait and get another town, because obviously it's more efficient to keep going every day. So before we get to the last towns in the first tier, we're talking to the candidate or to the ballot question side and saying, you know, where do you want to go next? Are you seeing what you want to see? Do you want to go on ahead of time, so we can get our courier now? You know, it's a little easier. We do have the bonded courier that we use now for recounts as well as ranked choice counts. And so we just put them on standby, and then they go out and they get the next group, so that we don't have a day's lag or something in between, and we can just continue on with the count.
Thank you. Other questions or discussion on this? Representative Chiazzo.
Thank you, Mr. Chair. You know, I'm very appreciative of the fact that the process that exists now, the candidates do have input in terms of where to start if they do have concerns. I mean, typically, if they're going to initiate a recall, a recount, it comes from the candidate side of things. I also don't have a problem with the Secretary of State taking control of all of the ballots. I think that's great from a chain of custody standpoint. And I think the cost issue also has to play into that. I would be concerned if we had candidates kind of running around to individual towns or individual places and asking for recounts on a smaller scale, and then having the towns either have to go back and try and get compensated for those or something somehow. I think everything being the Secretary of State's hands, I think that's a little bit easier to manage. So based on that, I'm going to move the ought not to pass on this bill.
Second.
Okay, not to pass motion from Representative Chiazzo and seconded by Representative Tuttle. Further discussion. Representative Kinney.
Thank you, Mr. Chair. I just wanted to point out that my thoughts around the recount being able to start in one municipality or another was not to stay in the municipality. It would be handled the way that recounts are handled and go into the custody of the Secretary of State. And that will end up being my minority report as well. I'll work with that will be my whatever, I won't be supporting the current motion. Maybe it won't be a minority report. Geez, I shouldn't assume that. Gosh, but the way things have been going, I'm gonna guess that's where it's gonna go.
Right. Any further discussion on this? Okay, seeing none. The motion before us is ought not to pass. Karen, if you please, can you call the roll?
Senator Lucchini.
Yes.
Senator Lucchini, yes. Senator Hickman. Senator Hickman, absent. Senator Farren. Senator Farren, absent. Representative Chiazzo.
Yes.
Representative Chiazzo, yes. Representative McCray.
Yes.
Representative McCray, yes. Representative Tuttle.
Yes.
Representative Tuttle, yes. Representative Riley.
Yes.
Representative Riley, yes. Representative Supika.
Yes.
Representative Supika, yes. Representative Wood.
Yes.
Representative Wood, yes. Representative Kinney.
I knew my assumption was right. No.
Representative Kinney, no. Representative Harrington. Representative Harrington, absent. Representative Corey. Representative Corey, absent. Representative Dolph.
No.
Representative Dolph, no. 7 in favor of the motion, 2 opposed to the motion, and 4 members absent, Mr. Chair.
Nope, and I think the senator may be frozen. So the ought not to pass motion prevails. Representative Kinney, I think you already teed up your report very well, but I'll ask you.
I actually don't really understand it, so hopefully.
So what I'm trying to do is when there's a recount, if let's say, so in 2018, there was a recount in CD2, and I don't know how it began. I don't know how that recount started. I know that it was stopped partway through. But what I'd like to see be able to happen is maybe rather than gather all the ballots from all over CD2, which is a large area, and trying to get a courier to go to each individual town to get all of those ballots, that the person running the candidate in CD2 could pick municipalities, possibly based on issues that they had seen on election night. I know that in 2020, I heard from several people that there were issues at various polling sites where the counting machines, which in some cases were in municipalities where they hadn't had counting machines. I know my district, my town was a town that did not, we're really tiny. So recounting by hand wouldn't have been too much of an issue, but where the machines went down, so they ended up having to wait for a new piece of software from the Secretary of State's office that night to continue counting. And it was interesting that they seemed to see a difference somehow in where the numbers occurred. So I'd like to be able to see the ability to have a municipality be recounted, maybe prioritized.
Okay,
And this happened in a municipality with multiple wards. So like some wards had one candidate much further ahead than the other candidate. And then at the end, after having a machine get recalibrated, so to speak, the outcome was very different, very odd considering the candidates involved.
So the candidate who's selecting the recount and thus paying can be the one who selects.
Yeah, and they should go to the Secretary of State's office as any recount would go to ensure the proper chain of command of the ballots for there. It shouldn't be redone at the actual town. It should go, the recount should occur the way recounts occur today.
And they select municipalities, or they select also down to the ward level? That's what I was.
They could select down to the ward if they wanted to. It was my thought around it with when I originally said a board of canvassers, and I'm just trying to make it a little bit simpler, which I guess I'm not making it that simple, but
okay. Well, there was not going to be a board, right? So
correct.
Okay. So then do you allow me to work with Deputy Secretary Flynn to make sure I do it right? Because she, I think, really understands what you're trying to do and knows how to do it.
Sure. Yeah, that would be fine. And it may be just clarifying the rules that are in place so that candidates are more aware of what those rules are that are in place today to be able to pick and choose where to start with a recount. It's mostly for these larger recounts, if they are like CD1, CD2, governor, the Senate, US Senate, where they.
Do you want to limit it to them, or that's just?
I don't want to limit it, but that's basically where I'm coming from, is on those larger ones that seem to have. I'm sure there are probably some larger districts, even, I have real tiny towns, but Portland may be a little bit different. Bangor may be a little different than what I'm used to.
Thank you for that information.
Okay, thank you, Representative Kinney. And I just wanted to remind those absent, we'll have until noon tomorrow to cast their votes on this bill as well. So I think is that it, Janet, from our agenda for bills to cover today?
I hesitate to say yes, but I do think so.
Okay. Do we have any other business to attend to from your perspective?
Not yet, but we will. We have busy next couple of days.
Yes, indeed. Representative Wood.
Are we meeting tomorrow or just Friday? I'm sorry, I've been in and out of the meeting this morning, so I haven't gotten all the information.
We are planning on meeting tomorrow, yes.
Yeah, I think the plan, I think the plan's to meet tomorrow at 10, because we'd requested the AG to kind of weigh in on one of the gaming bills. And then Friday, obviously, we'll just try to move through everything that's left over. I think we're pretty much just gaming and marijuana pretty much left.
And lots of language reviews from Janet's perspective, I think, right?
Well, we don't know yet, but we'll get them eventually. So.
All right.
Well, we're doing a big push in EUT also. That's where I was jumping back and forth today. So I'll be jumping the next 2 days also. I'm getting really high with my jumps.
Representative Tuttle.
Yeah, Mr. Chairman, I was planning on rototilling again today, but I think I might skip it. Yeah.
Well, you need to prepare for the barbecue that we're having at your house today at 3 o'clock. So you might want to prep for that.
As Senator Lucchini would say, I'm not going to be here. Right, Louis?
That is right.
Representative Kinney.
Thank you, Mr. Chair. When it comes to language review, I know we have several new members on this committee, and those do not have to be done before our statutory end. We just need to have their votes. Is that correct? And we can just come back for language review later. Isn't that how it usually works?
Yeah, I
So-
can. Yeah, the process, I think, is still unclear on how we're going to meet once we're back in session, because I think we're going to be pretty much in the building every day. And so the POs kind of have to direct us on how to conduct committee stuff. But once we're in the building and as things come out, we'll either do it in person, and sometimes it'll just be like sent to your desk or something like that. And then if anybody has an issue, they can raise it. So we'll look for some clarity from the POs on how to do it as well once we're all in the building. I don't think Ledge Council voted. I don't know if they voted on how to do committee. I can't remember last week. I didn't really listen. Yeah.
Well, who listens to them anyway, Mr. Chair?
Okay, any other questions or comments from the committee? All right, seeing none, then we will conclude for the day. Thanks, folks, for all your hard work, and we will see you all tomorrow at 10 a.m.